I would like to acknowledge the Gadigal people of the Eora Nation, the traditional custodians of the land from which I am speaking today. I pay my respect to elders past and present and extend that respect to any Aboriginal or Torres Strait Islander people watching this premiere tonight. I am beyond excited to be bringing you our very first launch event of the year for issue 44.1 of the University of New South Wales Law Journal. I am delighted to be bringing you this launch from the Sydney offices of Allens, who is one of our oldest sponsors, with 2021 marking their 40th year of sponsoring the journal. As a leading legal academic journal in Australia, and one of the few that is entirely student-run, we are very grateful for Allens' support over the years, and our work would not be possible without it. I would like to thank in particular Lisa Miller for your support in preparing for this launch, and also Tim Stewart, staff partner at Allens, for agreeing to deliver the welcome to the firm. I know that this is probably a tired subject, but I think we can all agree that 2020 was an unprecedented year when COVID-19 first spread across the country and the world and impacted the lives of billions. That's why I'm so pleased that the journal is serving as a platform to discuss the legal implications of the pandemic in the thematic topic of this issue, rights protection amidst COVID-19. I remember the time when our editor for this issue, Drew Gillespie, first proposed the topic in March of last year when I was still serving on the General Board. I was listening to his pre-recorded election video when the in-person election was sadly cancelled, and I recall thinking how topical his thematic proposal was, which came off the backs of media reports of how COVID-19 was affecting the businesses, employees, women, refugees, the list goes on. I will leave Drew to talk about the contents of his issue, but suffice to say I am so glad that the journal can contribute to the ongoing discussions about the legal ramifications of the pandemic. Congratulations, Drew. It was an absolute pleasure working with you. Now I would like to thank our panel speakers, Mr Edward Santow, the Human Rights Commissioner at the Australian Human Rights Commission, and authors Professor Michael Legg, Dr Chris Martin, and Dr Sara Dehm, for kindly offering to speak on our panel discussing the thematic topic for this issue. Your knowledge on this topic will no doubt be very enlightening to our viewers, and I am personally looking forward to hearing your thoughts. I would also like to extend my thanks to each and every author who has been published in this issue, whether as a thematic article or a general article. Thank you for entrusting us with your work and for making the journal the esteemed publication that it is today. Thank you to the UNSW Law School for your unwavering support of the journal. I would like to thank in particular Professor Andrew Lynch, Acting Dean of the Law School, who will be delivering the vote of thanks. Thanks must also be given to the faculty advisors, Rosalind Dixon and Gary Edmond, for your time, patience, encouragement and support throughout the day-to-day running of the journal. Special thanks to the rest of the Executive Committee, Rebecca, Lillian, Alicia, Caitlin, Arnie, and our newest member and Drew's successor, Kari. You guys keep me sane, and I'm so glad to be working with some of the cleverest and kindest people I know. Lastly, but definitely not least, I would like to extend a huge thank you and congratulations to the General Editorial Board. You are truly the beating heart of the journal, and we would not be here without you. Thank you for weathering the stresses of editing, and I hope that you can appreciate the fruits of your labour in this issue. Without further ado, I would like now to hand over to Tim Stewart, staff partner at Allens, to welcome us to the firm.
Thanks very much, Tina. Before I begin, I would like to acknowledge that we're recording this session on the land of the Gadigal people of the Eora Nation, and we acknowledge their elders past, present and emerging, and all the elders past, present and emerging of all the land we work and live on, and their ancestral spirits with gratitude and respect. We at Allens are very proud to be a premier sponsor of the UNSW Law Journal for 2021. This is our 40th year of support for the UNSW Law Journal, starting at the foundation of the law firm back in 1971. Hopefully, I'm welcoming you to our offices, in which case we are very excited to host you here for this evening. If I'm not welcoming you to our offices because of a COVID issue, we are also very excited to be hosting the recording of this University of New South Wales Law Journal launch. I'm a very proud ex-student of UNSW and am equally proud of the support that Allens has been able to provide to the journal. The journal has always been emblematic of the times, and the thematic for this journal, Rights Protection Amidst COVID-19, is no exception. Society worldwide has been fundamentally impacted by COVID, and Australia is no exception. We've had lockdowns, we've had curfews, we've had border closures. If you just joined me as I finished that sentence and didn't know what I was talking about, you'd assume we're at war. And this is what a lot of the rhetoric from our leaders has come from. We're battling a virus, we're in it together, we're fighting together, we're wearing masks for each other. And as we've heard from one of our state premiers explicitly, and I, at the risk of misquoting, this is not about human rights, it's about human life. Is that correct? Why do these have to be opposing concepts? Nothing is black and white, as our press and some of our politicians would like us to believe. There is always nuance. And I, like a lot of you no doubt, look forward to exploring these themes in more detail in the panel discussion, and not least of all, in volume 44, issue 1 of the UNSW Law Journal. And with that, I would like to congratulate and welcome Drew Gillespie, issue editor, who we're also proud to say is a current paralegal at Allens. Thanks, Drew.
I would like to first acknowledge the traditional custodians of the land on which this launch is being filmed, the Gadigal people of the Eora Nation, and pay my respects to their elders past and present. As we discuss the journal's theme today, Rights Protection Amidst COVID-19, it is important to acknowledge that Australia's Indigenous people have faced arguably the greatest denial of rights in Australia's history, and that there is much progress still to be made on the path to reconciliation. Welcome to the launch of issue 44.1 of the UNSW Law Journal. This issue is the first under the journal's new publication structure, under which 2 issues a year will be comprised solely of general articles, while the other 2 will be comprised in half of thematic articles and in half of general articles. This 13-article issue falls into the latter category, with 7 articles following the issue's theme, Rights Protection Amidst COVID-19, and 6 articles of a general nature, each focusing on independently chosen topics of legal scholarship. Issue 44.1 as it stands today almost did not happen. My initial idea for 44.1 was still focused on COVID-19, but based solely on the issues of contractual frustration and force majeure. These doctrines essentially cover what happens to a contract when unexpected circumstances render it incapable of performance. This situation was especially relevant as the commercial world grappled with the start of widespread border closures just over a year ago. Nonetheless, I was advised that this topic was too narrow for an issue. This advice wasn't wrong. Of the 7 thematic articles, none deal with the contractual rights of frustration and force majeure. However, I couldn't be happier with how issue 44.1 has turned out. The ultimate theme of the issue, Rights Protection Amidst COVID-19, covers a broader range of legal rights, substantive and procedural, domestic and international, and how those rights have been or should be protected during the ongoing pandemic. The 7 articles comprising the thematic component of issue 44.1 represent a diverse and deeply insightful body of scholarship. Each article's take on a discrete COVID-related rights issue reflects legal academia's key role in interpreting and grappling with novel laws and factual scenarios. I'm incredibly grateful to have overseen this body of works to fruition, and would like to thank the authors of the thematic articles for each taking the theme in a unique direction and entrusting the journal with their work. I would also like to thank the authors of the 6 general articles, whose works cover a wide range of fascinating legal topics. The topics covered by the general articles include the 2018 Australian High Court's constitutional term in its interinstitutional context, the potential use of corporate culture as a regulatory mechanism, the role of social entrapment evidence in self-defence cases involving intimate partner violence, the constitutional validity of using the Australian Defence Force during the recent crises of COVID-19 and the bushfires in Australia, the notion of substantial identity in Australian trademark law, and lessons for Australia from the UK's regulation of financial advisors. This wide breadth of topics covered in the thematic component of the issue. In addition to thanking the authors, I would like to thank our premier sponsor, Allens, for hosting the launch of issue 44.1. I am very grateful to work here and for the firm's provision of facilities for this launch. Many thanks also go to the journal's editors and those who have been members of the executive committee during my tenure as issue editor. This issue wouldn't have been possible without your help and moral support. I am extremely grateful to have worked with such intelligent and like-minded individuals. Many thanks also goes to the anonymous peer reviewers, whose thoughtful comments strongly contributed to the quality of articles in issue 44.1. I would also like to thank the journal's faculty advisors during my tenure, Professors Rosalind Dixon and Gary Edmund, whose input into my proposal and call for submissions for issue 44.1 and the journal's administration more generally is greatly appreciated. Last, but by no means least, I would like to thank those who have been close to me over the past year. Your encouragement, interest, and empathy has been greatly appreciated. I'm very lucky to have had you in my life. I would now like to welcome the guests of our panel discussion, who will introduce themselves shortly. Thank you all for coming today. So to start, could you please each introduce yourselves and the work you've been doing either in this issue or in the Commissioner's case, your own work over the past year during COVID?
I'm Chris Martin. I work at UNSW Sydney in built environment. The work I did was on residential tenancy law and responses to the COVID pandemic, particularly the eviction moratoriums and the rent variation regimes.
Hi, my name is Sara Dehm. I'm a senior lecturer at the Faculty of Law at UTS, and I research in the intersections of international law and Australian refugee law and policy. My article in the special issue is a co-authored piece together with two colleagues, Dr. Linda Steele, who is also at the Faculty of Law at UTS, who researches on disability rights and aged care, and also Dr. Claire Lochnan, who is a lecturer in criminology at the University of Melbourne, who researches across immigration detention and other sites of confinement such as aged care. And our collective piece was perhaps somewhat counterintuitively trying to compare and contrast the Australian government's COVID-19 response across those two sectors, so immigration, detention and aged care, and thinking about them as sites of confinement, but also trying to think about the ways in which strategic litigation in response to COVID that played out across immigration, detention and aged care sought to challenge the particular what we call logic of disposability or logic of confinement that played out across both sectors.
Terrific. My name is Edward Santow. I'm the Australian Human Rights Commissioner. We at the Commission have been very alive to the many human rights implications of the COVID-19 pandemic. We observe that a number of the measures that have been introduced in response to COVID are explicitly to uphold human rights, most obviously the right to health. And that's a really good thing. Of course, some of the measures are more complex because they may have the explicit intent of protecting public health, but they may also impinge on other rights, most obviously freedom of movement. We've all experienced through lockdowns and so on how that can have a really profound effect when you cannot visit family, friends and other loved ones. And so I guess what human rights law offers in this context is a way of reconciling when those I guess impetuses come into tension. A human rights approach really emphasises the importance of making sure that when you are seeking to advance a legitimate interest, like protecting public health, that you do so in a way that only impinges to the minimum extent necessary on other basic human rights. And so in terms of the journal itself, it's been such a pleasure reading all of the very learned and nuanced and sensitive analyses that are contained in this particular edition. I've had a very simple task, which is just to write the foreword, which can pick out some of the eyes of those pieces, and it's been an enormous privilege to do so because they are of such high quality.
Thanks, Ed. So my name is Michael Legg. I'm a Professor of Law at the Faculty of Law and Justice at the University of New South Wales. I'm also the Director of the Law Society of New South Wales Future of Law and Innovation in the Profession Research Stream. And the article which we've contributed to the special edition is on So it's written with my co-author Tony Song, who's a recent UNSW law graduate. And what we focus on is the justice system and the impact of fully remote or online hearings, and how that has had a role in terms of both access to justice, but also in relation to the way in which hearings are conducted, and whether those sort of essential characteristics of the justice system are changed or preserved in that sort of online environment. Thanks.
So on to our first substantive question. The question, so to start us off, we have, do you think Australia was adequately equipped to face COVID-19 without any serious detriment to individual and group rights? And also, has it succeeded in doing so? So
I think it's a big question, and I think it would be fair to say that by and large, Australia probably wasn't adequately prepared to approach COVID-19 and the Australian government's response to COVID-19 using a human rights perspective. I can talk to the area that I research in, which is immigration policy, and specifically immigration detention. And I think it's fair to say that across the Australian government's treatment of people categorised as non-citizens and also people in immigration detention, that they have largely been, I would say, abandoned by the Australian government, or not treated in a way that could have adequately protected them in relation to the pandemic. So under Australia's regime of mandatory indefinite immigration detention, the minister has large discretion to issue or to release people from immigration detention. And we saw that the minister didn't do this at the start of the pandemic, despite expert recommendations from doctors, from the Australian Human Rights Commissioner, to reduce the number of people in confined institutional settings, because the very fact of being within a confined institutional setting largely increases their risk of infection and potential harm as a result of contracting COVID-19. And so I think there has been a lack of accountability in relation to how that executive power was exercised in relation to people in immigration detention. And the fact that the minister has been able to release people, so we've seen in the last few months that refugees who were transferred from Australia's offshore detention regime to hotel detention and who had been in hotel detention for over a year now, the fact that the minister was able to release them in the last few months shows that there are alternatives and that it is possible to do so. So it's unclear why those releases couldn't have happened at the start of the pandemic, particularly because people in immigration detention were saying that they were really fearful of contracting the virus, that they couldn't adequately social distance within immigration detention centres, and that they weren't necessarily being provided with PPE either in order to implement the recommended government COVID-19 guidelines. And I'll just say that alternatives are possible. So we saw different responses elsewhere. So just to use some examples, I think it's worth reiterating how, I guess, unique Australia's system of mandatory immigration detention is. So in the UK, they do have a system of immigration bail, and at the start of the pandemic, UK courts and tribunals were ordering the release of people from detention because of the risk that COVID-19 presented. In Spain, for example, they have a mandatory limit on immigration detention, which is 60 days, after which, in general, a person's detention becomes illegal, particularly if deportation can't be effected. And so the courts in Spain also ordered that people should be released from immigration detention. And similarly in the US, the courts do have much more oversight over a person's detention. So I contrast this to Australia, where we have no maximum time that a person spends in immigration detention. I think the most recent statistic is that on average, a person spends over 600 days in immigration detention, which is close to 2 years, which is, I think, just a shocking statistic. And the fact that the pandemic didn't change that, I think, is a real cause for concern. And in fact, the Migration Act explicitly tries to prevent the courts from releasing people from immigration detention as well. So I think just looking at Migration policy is one sort of example. I think Australia has a long way to go in terms of how we treat non-citizens through a human rights approach, and I could draw on lots of other examples, but I'll leave that to my fellow panellists.
I might make a general observation, and I think I agree with everything Sara just said. I think it's a mixed bag. I think I was pleased with some aspects of the response from a human rights perspective, in that there was a recognition reasonably quickly in Australia by federal, state and territory governments that this was a serious problem. It needed to be addressed, that there would be kind of direct health consequences, and those kind of indirect negative consequences would flow out. So things like JobKeeper were instituted reasonably quickly, and I think it's important for me to acknowledge that those things have alleviated hardship in a very real way for people. I think that the point that Sara makes very, very powerfully is that there are significant numbers of people. We're not just talking about small groups, we're talking about very significant numbers of people who have not been included within that safety net. And those people, I think I'm deeply worried about, particularly as time goes on, and what perhaps we all hoped last year might be a very sort of short and sharp problem has extended, to be a longer term one. And so maybe I could sum it up this way. In one sense, we had sort of strong cultural protections that kicked in, which meant that there were a number of groups of people who were, I guess, shielded from some of the worst of the direct and indirect impacts of the pandemic. But I think it's really shown up some of the structural weaknesses in our system. The fact that we don't have a National Human Rights Act or Bill of Rights, I think is really significant, because it means that people who don't immediately come to front of mind don't have the same level of legal protection that other people in the community might be able to almost take for granted. And so I think that's something we really need to get to grips with as we move beyond this initial phase.
Thank you. Michael, would you like to speak?
Sure. So I guess just a slight detour in terms of background. So the rights that I'm concerned with are access to justice and access to a fair and public hearing by an impartial tribunal. And I guess whilst they are undoubtedly human rights, often they're not necessarily, I guess, focused upon because we have a court system and it's functioning here in Australia. But I think it's worthwhile, I guess, reiterating that what we're talking about here are procedural rights, and they exist in our system, I guess, coming from a number of different areas. So the common law recognises these. You can go back to Magna Carta to be able to find them. They've been implied into the Australian Constitution and what it means to exercise judicial power. But you can also find them in human rights instruments. So Article 10 of the Universal Declaration of Human Rights. So when we talk about being adequately equipped to face COVID, what we're really doing is looking at our justice system, courts and lawyers, and asking whether they functioned effectively. And so it's not just whether they could continue to function or continue to operate, but the sort of the quality in the way in which they operated. So were they operating consistent with providing a fair hearing? So there's two components there that need to be focused on. So what the article, I guess, does is it sort of explains how, in many ways, courts and lawyers rose to the occasion and indeed were able to sort of maintain the justice system and access to justice continued, sometimes through court-provided technology, sometimes through Zoom, which we're now all very familiar with, and other times just through the humble telephone. But it was able to continue. The much more difficult question is whether there was detriment. And that's because I think the way that the courts and tribunals approached the situation was, if a person's procedural rights were at risk, they were typically given serious consideration. So, individual judges would look at that and would try to address them to take away any unfairness. And if they couldn't, then the response would be an adjournment. Now, whilst the adjournment means that the hearing's not conducted in an unfair manner, it also means that there's no hearing. So your access to justice is not there. And as a former High Court Justice, Sir Gerard Brennan once recognised, when you don't have access to the courts, it's not just a case of creating backlog. I will get to these at some later time in the future. It actually endangers the rule of law, because people are then unable to use the law to resolve disputes. The law can't be accessed. So when we then look at where cases did go forward, was there unfairness? Well, that's a question that we don't really know. And we need to really get more data, and it may play out through the appellate process. But at the moment, we sort of know that our court system was there, it continued to operate, but we really do need to look more closely at how it operated during the pandemic.
Thank you. Chris?
Well, my focus was on the right to housing, and in particular, the right to housing of renters, of tenants. And I think that the pandemic showed clearly how weakly protected is the right to housing in our pre-pandemic housing system. So our tenancy laws allow for the very ready termination of tenancies. Tenancy laws very weakly protect tenants' security in their homes, and also the affordability of rental housing. And I think that we had a mounting problem in our rental sector coming into the pandemic. 2/3 of private renters who are on low incomes were in rental stress coming into the pandemic. A third of them didn't have $500 saved for an emergency. So I think faced with the sudden stay-home imperative and the suppression of economic activity and the income shock that happened, what had been the quiet desperation of rental households became a very real focus of public health risk. And that's why governments moved as quickly as they did to implement the eviction moratoriums, and also this encouragement for landlords and tenants to talk about or negotiate their rent obligations. So we saw some real innovations in the pandemic period in the emergency measures, particularly around the eviction moratoriums. No state or territory came up with a complete moratorium on evictions, and that they all varied quite a bit in the coverage. But there are some things coming out of what they did as an emergency measure that I think we can learn from as ongoing reforms to improve the protection of people's housing in the rental housing sector. And also there might also be some things to learn around, some more critical lessons to learn around affordability, the affordability of rental housing, because that was an area in which the response, a mere encouragement for parties to negotiate, didn't really seem to have a very strong effect, something that's emerging from the research I've shown in the paper. So I think this is an interesting thing about crises, and we've just been through one. This idea that they're a time of change in the law, and change in the way societies conduct themselves, and just how much of that change or potential we see going forward when a lot of the framing about this present crisis is how do we get back to normal? getting back to normal in terms of housing, our housing normal wasn't good. And we need to be looking for the lessons of this crisis for a better and improved protection of people's housing rights.
Thank you, Chris, and thank you all for those very insightful perspectives. Our next question is, how accessible do you consider avenues of rights protection to be, and how accessible do you consider them to have been throughout the pandemic?
So I've noted before, Australia is not a jurisdiction that has a national Human Rights Act. Of course, we have 3 jurisdictions now at the state and territory level that do have Human Rights Acts, and that's a good thing. What it means is that if someone is claiming that their rights have been infringed under the International Covenant on Civil and Political Rights, and it's the federal government's responsibility, they can come to the Human Rights Commission. We exercise an unusual jurisdiction there, so we can provide a forum for conciliation between the individual and the federal government. But if the government doesn't wish to participate, or if that conciliation doesn't yield a result that everyone's happy with, then all that really falls to us is to, at most, issue a report that ultimately is tabled in Parliament. So that's not a determinative power. In other words, we don't have the power to actually, force a result. But also, unlike anti-discrimination law, where people have that same process that they can engage in first, an informal conciliation process that the Commission runs, for discrimination, they could then take their matter to court. For other rights, they can't. That's the end of the road. And that's tricky, because we know that there are a range of issues that people still are concerned about. So the right to family life is very much engaged by people who are trying to get back to Australia from overseas, and we know that there are still many thousands of people who are unable to do just that. But the capacity to actually kind of get a judicial result on those disputes just doesn't exist, and so that's I think a gap in our legal protections.
Michael?
Well, I guess so. To answer that question from the perspective that I have been looking at it, I guess we're talking about when we talk about what's accessible, we're talking about access to justice or access to the justice system. And I guess the way that we need to focus on that is that courts, tribunals, other methods of dispute resolution are all readily available in Australia. But you come back to an old quote, which is, justice is open to all, like the Ritz Hotel. In other words, we've got this top-notch justice system, and anyone can enter. Self-representation is, perfectly okay. But to get the system to work for you and to really protect rights, you need to have money. And the reason you need money is because you will achieve a better result if you're able to get legal representation. And so when we talk about accessible from the perspective that I'm looking at, what we're really talking about is affordable. Can you actually afford to be able to get legal representation and access the justice system? And I think that is, in some ways, it's a nuanced question, because when we talk about things being accessible, we really need to focus on a range of issues. So one is legal fees. Another is the forms in which legal fees can be charged. So there are ways in which you can defer the payment of the legal fees, such as a conditional fee agreement, which may help. There's ways of being able to bring a claim where people can join together, such as a class action. And then, of course, you've got government funding through things such as legal aid and community legal centres. And then, of course, the legal profession will assist in terms of pro bono. So there are ways in which making the justice system affordable can be achieved. But I don't think I can give an absolute answer. I think rather we have to recognise that access to justice, you can only achieve that if that access is affordable. And I think we've got work to do in the sense that there's a range of mechanisms that are out there that could be used. And I think at the moment, it's not sufficient. It's not like all citizens are able to access the justice system, but we need to work more on trying to work out exactly how we pick the right mechanism to help the various people. Thank you.
I think that segues really nicely to what I was going to say, which was focusing on the ability or the lack of human rights legal mechanisms, if you like, in Australia for enforcing or guaranteeing or ensuring the rights of refugees, particularly refugees in immigration detention. And I think questions of accessibility are really heightened in relation to non-citizens, particularly in institutional settings like immigration detention. And so I think what we've seen in recent years is a really interesting and sort of creative turn by people in immigration detention to using strategic litigation in collaboration with lawyers acting on a pro bono basis in order to achieve human rights outcomes for a cohort of people. And we've seen this, particularly in the last few years, used successfully for refugees held in Australia's offshore detention regime on Papua New Guinea and Nauru, to use court orders to compel the Australian government to transfer people to Australia so that they can receive medical treatment and thereby have access to decent healthcare. And so during the pandemic, we saw a new use of this strategic litigation as a form of human rights accountability for people in immigration detention, using negligence principles around the Australian government's duty of care towards people in immigration detention, which are established principles of law, but arguing that the scope of that duty extended to also taking steps to ensure that people didn't contract COVID-19 in immigration detention and that they could also follow government COVID-19 social distancing guidelines. Unfortunately, there were two key cases that were brought by people in immigration detention in the first few months of the pandemic, so in April, and neither of them were particularly successful in compelling the government to release people from immigration detention. So for one, the fact that the factual basis that the claim rested on, the fact of COVID-19 community transmission, the fact that community transmission in Queensland had decreased meant that this particular litigation was discontinued. The second litigation was slightly more successful in that they were able to get a federal court order ordering the Commonwealth to no longer detain a refugee in a Melbourne immigration detention facility. However, the government response was to transfer this plaintiff, who was an elderly man, away from the Melbourne Detention Centre to a detention centre in Western Australia, where he was removed from his family in Melbourne and his extended social network. So I think whilst strategic litigation has been used really interestingly and successfully in the refugee space to try and provide some form of human rights accountability, unfortunately, in the context of the pandemic, the cases that were brought were faced with, I guess, a government wedded to using immigration detention in largely, I think, punitive ways. That said, I think the cases were successful in galvanising public opinion and making a case for why keeping people in immigration detention posed an ongoing risk to their health as well as to the broader community as well. So, but I would reiterate exactly what both of you have said around the lack of human rights legal mechanisms, as well as the issue of accessibility in relation to bringing cases like this, because of course the litigation is costly, time-consuming, and relies upon lawyers, particularly for refugee clients acting in a pro bono capacity.
In the area of tenancy law, residential tenancy law, all the states and territories do have relatively accessible tribunals through which disputes between landlords and tenants can get resolved. But the real focus of those tribunals, particularly when they're dealing with termination and eviction proceedings, is it's for the ready but orderly termination of tenancies. So we still have provision for tenancies to be terminated without grounds, and where there are grounds, the proceedings go through the tribunal, but quite often tribunals will be just restricted in whether they can decline to make termination orders depending on the circumstances, and it's really quite a fast process as well. So I think the focus of our accessible tribunal system as regards residential tenancy law has been on the ready but orderly termination of tenancies, and there's a real strain between tenancy law, as we've enacted it in all states and territories in Australia, and the international jurisprudence on the right to housing. So in international law, in the international decisions of the committee, complaints of the committee, and commentaries by the committee on the convention, there's an emphasis on eviction and termination always being justified, it's the last resort, that eviction should never be into homelessness. Also, regarding rent increases, that the principle of affordability should play a part in rent increases. Our tenancy law doesn't apply those principles at all. Ready but orderly termination and really market rents and little provision for affordability being a factor. Some of that changed a little in the pandemic period, and I think there are some lessons that we might take from those emergency measures that might actually be more enduring reforms that better protect and better implement the right to housing.
Thank you all. Very interesting responses again. Our next question is, how could the executive, legislature and judiciary have improved their responses to COVID-19 in order to ensure the protection of rights, so in your respective fields?
Sure. So I guess in the context of immigration policy, I guess I have two sort of key ideas or contributions that the government or the executive could have done in order to improve its COVID-19 response. The first one is fairly straightforward in relation to immigration detention, and that is to listen to the advice of medical experts and the Australian Human Rights Commissioner to try and decrease the numbers of people in immigration detention. I think that could have been a very easy thing for them to do, a very simple thing to do, and it would have ensured that people could follow government COVID guidelines around social distancing in a more self-directed way.
And just on that, if I can just interrupt, I mean, a year ago, the immigration detention population, so closed immigration, was about 1,300. Now it's over 1,500. So it's increased quite significantly in that period. By contrast, pretty much every other jurisdiction we would compare ourselves to has significantly decreased, often less than 50% of the, it's decreased by 50% or more, the number of people in immigration detention. So while we're going that way, everybody else has been going that way, which I think is really, really significant. And it does sort of bear out the point you're making, which is that there's a real risk there, and we are taking an approach which is exceptional as compared with other jurisdictions.
And I think that then should prompt us towards legislative reform. So the fact that we're leaving the power to detain people indefinitely in immigration detention to executive discretion under our policy of indefinite mandatory detention, I think, and the fact that that policy didn't really shift in a global pandemic means that I think we need to have greater oversights for the courts and through legal reform. So at its most simple, I would say that we do need to work towards unwinding or repealing Australia's policy of indefinite mandatory detention. and I guess it's more simple, or at the bare minimum, potentially implementing a system of immigration bail like they have in the UK. But I guess I think the better reform would be to try and do away with this policy of trying to detain people, because there are options, alternative options, such as providing people with supported accommodation in the community. So I think that's the first key reform that I think should have happened in response to COVID-19. The second one in immigration policy would be to have implemented, or to implement now, a immigration amnesty, akin to what Australia has had in the past. So we have had 3 immigration amnesties in the 1970s and in 1980. And that would have allowed non-citizens living in Australia to regularise their status, so that they can have access to economic support such as JobKeeper, or to housing support as well. So this is something that labour law experts have called for, community advocates, a peak union, as well as, interestingly, some National Party MPs. There's an estimated sort of around 65,000 people living undocumented, that is without any legal status, in Australia. Over 6,000 of these people are estimated to have lived in Australia for over a decade or more. And being undocumented has huge implications for access to decent housing, decent healthcare, the COVID-19 vaccine, for example, as well as other government support. So I think trying to regularise the status of this cohort of people would make a really significant difference to ensuring that this cohort of people have access to some fundamental rights.
In terms of the role of the different branches of government, in relation to residential tenancies and the rental housing sector, there were some interesting developments in the response. So the way the eviction moratoriums worked, it's difficult to generalise because all the states came up with their own thing. But one of the themes of it was that termination proceedings would be more scrutinised. So, and that might be, in some states it was a prerequisite that the landlord and tenant go through a negotiation process or a conciliation process, or there's a higher qualification on looking at hardship, or a higher qualification for termination if it gets to the point of a tribunal member determining a termination proceedings. So that was one of the moves made by the emergency measures as regards evictions. There was more scrutiny of termination proceedings and a higher level of justification required of landlords. As regards rent variations, that was something where the state really backed off, and we didn't get much beyond that initial response at the very outset of the emergency, where the Prime Minister and other ministers just encouraged landlords and tenants to have negotiation amongst themselves. And when states came up with legal frameworks around, they came up with frameworks that still, at the core of them, was a negotiation between landlords and tenants. And there was a real resistance by states. Only one of them really made provision for this, for a tribunal to make a determination of what a rent variation should be. So there was a lot of resistance to the idea that rents could be reduced, or more specifically that the state could intervene and determine that a rent variation should take place. So I think it shows that rent regulation, which is something lots of other countries have private rental sectors and rent regulation, a regulation of rents that takes into account some measure of affordability or some moderation to what the market will set rents at. We've sort of lost sight of that here, and rent regulation is a bit of a lost art in Australia, and I think that was revealed in the emergency measures.
Michael, Well, I guess so. Focusing on the operation of the justice system and I guess procedure, there's probably I guess two main lessons that came out of the preparing the article and looking at what had happened in terms of the pandemic experience of fully remote hearings. The first one I think is not very surprising, which is if you want to have a remote hearing, then the technology needs to function. It's like the very first hurdle. If you're unable to sort of dial in to your trial, it's a bit hard to participate. So I think in terms of responses, I would recommend that there needs to be more investment in remote hearing technology, particularly I think in the lower courts and tribunals. We're aware that a lot of them, relied on telephones to be able to, conduct like directions hearings, etc. It shouldn't be that expensive for government to be able to properly resource those courts. And then in line with being able to use the technology, more training for judges. And not just in terms of, do I know how to turn the technology on, but in terms of how to manage an online hearing, because that is actually quite novel. And so one would hope that having now done it through the pandemic, experiences will be shared between various judicial officers, and hopefully also bringing in the profession for them to be able to share experiences, but also talking to the actual parties, the people that were part of these hearings, how did they find it, and being able to share that. And then I guess the other thing to keep in mind here is there also has to be investment in infrastructure at a society level. If you don't have adequate bandwidth, then your remote hearing is not going to work. And so it's really about looking at making sure that the technology is there at the infrastructure level, for people that may happen to be in regional, remote or suburban areas, not just in the CBD. And then the second, sort of response is to, and this one I think is perhaps a little more out there, if I can put it that way, but to consider whether there are additional values that we need to take into account. So the article focuses a lot on procedural fairness, openness, and impartiality, which are like the three pillars of a fair hearing. But if we're actually moving to remote hearings, then I think there is, it's worth thinking about, well, how do we want those to be conducted? Are there values that we want to see reflected in them? There's three that I would suggest. One is maintaining human or at least humane interactions, and trying to recognise that we still have got a person whose rights are being determined by what's going on here. The second is security of the technology. That's an aspect which I think society more generally is starting to see as something we need to focus on. Clearly, if we're dealing with sensitive issues being determined through remote hearings, the security needs to be there. And then the third is accessibility or convenience. The remote hearing obviously provides for that because you're able to be almost anywhere. And so I think we need to sort of make sure that we if that's possible, and it's going to assist in terms of access to justice for people who might be in remote locations, that we do in fact use it and make it available. Thanks.
Yeah, so maybe I can make a general observation. So in ordinary times, there's a constructive tension between our three arms of government, the executive, the judiciary and the legislature. In any time of crisis, be it a war, as Tim Stewart alluded to, or a pandemic, as we're now experiencing, that tension still exists, but it's different, right? Almost inevitably, the executive will take on greater responsibility, which is code for greater power. That happens because we need to move urgently to respond to the crisis. So I accept that general principle is true. And we've seen that play out. So what it means, for example, is the executive has relied much more on non-disallowable legislative instruments, a technical term that is not well understood even by lawyers. It means, essentially a minister promulgates a regulation. Ordinarily, either House of Parliament can move within 15 sitting days for that to be, disallowed. What a non-disallowable legislative instrument does is exactly as its name suggests, it can't be disallowed in the ordinary way. Essentially, the only way of pulling back from that exercise of ministerial power is to pass primary legislation. That's a hard thing to do for anyone other than the government. And so it really, those sorts of things which have increased, they really do alter the level of scrutiny, independent scrutiny that exists. And we've seen, from the work that Michael and others have done, that the way in which the courts can exercise their oversight functions has changed over the pandemic. So what do we do about it? Do we just accept that lower level of scrutiny is what we have to deal with? I think that's probably a bit simplistic. I think what we can do and what we should do is think more creatively about what can be the alternative forms of scrutiny that need to come to the fore during a crisis period. So we've seen, I think, some positive responses. So the creation of a special parliamentary committee with responsibility for overseeing some COVID issues, well, in a sense, all COVID issues in theory, I think that's a good step. It's a very, very big mandate, and it's a very heavy responsibility, but an important one. And so I think what we probably should do is consider for this crisis and for the future, what are the things that we can put in place that would allow us to move urgently and expeditiously, as we need to do, but also retain some really important scrutiny of some of those measures.
Thank you. Thank you. So you've all just talked about potential reforms in your field. So now moving on to, do you think that from COVID there are any areas or any reforms which have taken place which are likely to be permanent or have a lasting impact on rights protection in each of your work?
I'd like to think so. In particular, what I've characterised as the increased scrutiny applied to termination proceedings for tenancies, and the higher level of justification that's been required of landlords in termination proceedings. That could be made permanent. And in fact, the period we're in now, where just this week, eviction moratoriums are lifting. In New South Wales, that's been accompanied by a further legislation for a transition period. And that has maintained an element of the moratorium, which is that there'll be a scrutiny applied to termination proceedings for rent arrears, and a requirement that there's been some sort of negotiation between landlords and tenants. So that's a hopeful sign that a lesson has been learned, and even though they're still calling it transitional, maybe it should be permanent, that sort of additional scrutiny of proceedings. There was also a turn away in some jurisdictions from no grounds termination proceedings, which is, really that's a way of terminating a tenancy that avoids scrutiny, because there's always a reason, but the landlord doesn't have to say what it is when there's provision for no grounds terminations. Some jurisdictions dispensed with no grounds terminations during the moratorium period, and that's something that could be maintained longer. Victoria already had a reform on the books that will now take effect with its moratorium lifting. It has a reform coming in that will really limit the ability of landlords to give no grounds terminations. It really narrows the availability of them. So there are some lessons that I think come out of the moratoriums that are important and could be carried on as a permanent part of our system. There's something I haven't discussed so far, another issue that came up in the research and in the paper, and that's around property rights. And this could be this comes up as a potential impediment to reform, and in particular, the constitutional protection that is given at a federal level, and it also, by extension, at the territory level, not the states, but at the territory level, constitutional protection given to any property owners' property interests, and the protection is that governments only acquire property on just terms. That might seem a bit of a reach from the sort of tenancy legislation that the Australian governments have been enacting for the last 45 years, but it actually came up in the Northern Territory's response, where they were concerned that if they went too far with eviction moratoriums and rent variation frameworks, does that start to effect an acquisition of property by the government, an acquisition of the landlord's property interests? So that's an interesting argument, I think a dangerous argument for housing rights. I think, and I spent some time in the article trying to explain why it isn't a good argument, and why property protection, or the constitutional protection of property rights, doesn't actually go so far as to restrain governments from regulating in a sensible and reasonable way that improves tenants' housing rights. But the fact that it came up there in a real way in the Northern Territory and in a rhetorical way in some other jurisdictions is something we should be alive to in putting the case for tenancy law reform.
I wonder if I can make an observation off the back of Chris's excellent comments and excellent article looking at housing. But before I was Human Rights Commissioner, I did a lot of work on homelessness. And one of the things that always struck me as a very difficult irony to convey was, there's over 100,000 people tonight in Australia who will be homeless. And yet, if you haven't experienced homelessness yourself, it is incredibly difficult to imagine that will ever be you. The experience of working with and for people who've experienced homelessness suggests that actually all you really need to have is some really bad luck of some bad things happening all at once, and that can kind of result in you yourself ending up homeless. So the reason I say all of that is I think what this pandemic has shown is that sometimes just bad luck comes at us out of nowhere, and we are perhaps more vulnerable to that bad fortune than we realised. And that's an incredibly uncomfortable realisation, but maybe it's an important one, because I think with the way in which governments and the Australian population more generally realised quickly, we need to put in place the job keeper scheme. We need to increase the job seeker payments, and otherwise the consequence could be utterly catastrophic. We need to remember that lesson, because those lessons apply to many of us, perhaps even, at least in principle, all of us, in normal times as well. And so that approach where we take very seriously the human rights of every single person, and we put in place a safety net that is adequate in respect of every single person, is one that I'm desperately hopeful that we hold on to.
Yeah, I very much agree with that. I think it's a really important lesson that's come out of the pandemic, that it is possible to provide a stronger and more decent social safety net for people in Australia. And I think it's really unfortunate that non-citizens were largely excluded from that safety net. So international students did it really tough. Refugees on temporary protection visas were excluded from JobKeeper, as were migrant workers. And again, I looked to other states overseas, OECD states such as Portugal, who took a very different approach. So they temporarily decided to treat all non-citizens within Portugal as permanent residents effectively for the early period of the pandemic. And I think it's really unfortunate that we didn't see an approach like that in Australia, particularly for people that have been in Australia for a long period of time. So whilst I'd also like to be optimistic and say that the pandemic may give rise to sort of structural or systemic law reform in the area of immigration or immigration detention, unfortunately, I don't think that will be the case. But I do think one of the things that we can hold on to from the pandemic was the social and legal mobilisations that came out, or that we saw over 2020 in relation to people galvanised in order to try and protect their rights in creative ways. So we did see mass protests, both in terms of Black Lives Matter in 2020 and also in terms of refugee rights, although some of those protests were criminalised. So certainly with the Black Lives Matter protests, they had to fight it in the courts in order to get the clearance to go ahead with some of the protests. And some refugee activists were also issued fines for breaching public health orders. So I think that's a really concerning trend. I mean, even though, of course, we need to take public health orders very seriously, they do then also have implications for the right to freedom of expression in Australia. And certainly if other large mass gatherings can go ahead, then I think we should really jealously guard the right to protest as well as a form of human rights politics or accountability as well.
I guess in the situation of remote hearings, in some ways it seems pretty clear that remote hearings are going to stay with us. There's been a number of statements from various judges that there's no going back, that this is going to be the way in which justice will be able to be administered in the future. But I think we have to unpack those statements. And so I think we have had some courts who have provided data around, these were the number of matters that were able to be heard and these were the matters that needed to be adjourned. But really, we need to know more than that, because I think it's the question is not will we allow remote hearings? The question is when should they be used, and are there circumstances when they're not appropriate? And so to be able to answer that, we need data, and the sorts of things that I think we need to look at is, where a case did go ahead, how did it go ahead? Was it audio-visual? Was it just a telephone? What sort of technology was used? But we also need to break it down in terms of what type of matter were we looking at? What was it? Criminal, family, or civil? And what type of evidence was there involved? Was it simply documentary or was it oral? Were there more sensitive issues that needed to be dealt with in that case or not? I suppose in general, what was at stake here? And related to that, what sort of hearing were we dealing with? Was it a directions hearing? Was it a full trial? So, we're actually talking about rights being determined, or was it an appeal? And so really, I think in terms of, the future of the remote hearing, it's about getting more granularity around how they were used and how they can be used. And I think we may get some of that through the appellate process. So we might see some appeal courts who will be asked to sort of weigh in on whether procedural fairness was maintained. But really, it's going to be, I think, up to the Academy to do further research on this to determine how it can be used.
Thank you, Michael. Thank you all. In the interest of time, we're going to have to wrap up. But thank you very much for coming today, and thank you for your very comprehensive and thoughtful comments on the questions. That definitely helps it shed some light on the issue topic. Thank you for coming. It's been great to talk.
Thanks.
Thanks.
Thank you.
Hi, my name's Andrew Lynch and I'm the Acting Dean of the Faculty of Law and Justice at UNSW, and it's my great pleasure to make a few short remarks as a way of thanks. It's been over a year since COVID-19 led to an unprecedented implementation of regulatory control in Australian society, and it's really remarkable, I think, for the publication of Volume 44, Issue 1 of the UNSW Law Journal to be happening, addressing those issues with a great wealth of academic commentary so soon afterwards. So I really congratulate the journal and all who have been working on it in the years since to produce a publication of this quality and relevance and timeliness for us all to enjoy reading and thinking about and debating as we go forward from this point, as we emerge from the effects of the pandemic. I'm glad that we were able to hear the comments of Edward Santow, the Human Rights Commissioner from the Australian Human Rights Commission, and also a former colleague of mine and others at the UNSW Faculty of Law and Justice. It was wonderful to see Ed joined on the speaking panel by contributing authors to this issue and hearing from them about some of their thoughts behind the papers that they've written, and an update really on what they've been thinking about as the pandemic has played out since they submitted their papers for publication. UNSW is immensely proud of the Law Journal and our students who self and independently run this publication. I congratulate Tina Wu, the executive editor, for her work over the issues under her oversight. I thank and congratulate the entire team who have led to this production, but obviously single out Drew Gillespie, the issue editor, and thank him for his industry and congratulate him on this fine achievement. I also want to thank our hosts tonight, Allens, and I thank them for their sponsorship of the journal, which is enormously appreciated by the faculty because of the experience that it offers to our students, but also as an academic, the opportunities it offers to myself and to our colleagues all around Australia and the world to publish in such an incredibly fine journal, which adds to the profile and reputation of UNSW as a leading research and teaching institution in law. Thank you very much for your attendance tonight, and thank you again to all our speakers and our sponsor. Congratulations to the editorial team.
Thank you to Mr Santow, Professor Legg, Dr Martin and Dr Dehm for providing that wonderful discussion about the impact of COVID-19 on rights protection. This brings our proceedings to a close. Congratulations again, Drew, and thank you to all of our viewers who joined us tonight. All the articles of issue 44.1 can be found on our website at www.unswlawjournal.edu.au, and I hope to see you again soon for the launch of issue 44.2.